started while maybe 2 or 3 more participants would join in soon. So, yeah, welcome back everyone to the session. This is something, this particular session is something of great relevance to all of us because we live in this digital age. And Ashok and I, we were just discussing about the volume of content that is available today. At the same time, when we talk about the digital rights, all of you, I mean, I'm just also addressing this to the students, where all of us today are experiencing, access to a lot of content. While some content allows you to download, some portals allow you to download the material, make use of the material, etc. There are some portals which would only allow you to a read-only format. Or, there are many other restrictions that they might also have in order to protect their content, or like a disclaimer. Nagaraju very rightly mentioned in the last session that most of these video contents would also have a copyright notice, or they would have some other way of protecting their copyright or intellectual properties in the content. So this is exactly what we want to understand today as to how organizations protect these digital content, right? And how we as lawyers need to help our clients protect their very, very important data, very important digital content, because this is the easiest thing to happen today, right? So I making use of somebody's digital content is, or copyright infringement is not at all a difficult task today. When the long ago, when the printing press came itself, it was quite disruptive, they said, where they said it would be easier to make copies. What about the present digital age, where there is so much content and it's so far more easier for us to just pick on somebody's content and say this, I can just commercialize that. So how are organizations protecting this, and what is the role of lawyers in terms of helping their clients protect this digital content? So this is the theme of the present session, and I would like to invite Ashok to take this session on. And for those of you who are attending for the first time, Ashok is the founder partner of Factum Law, and he comes with a vast expertise in the areas of intellectual property rights, space laws, and commercial and business related laws. So this is just a brief about the instructor for the day. And over to you, Ashok.
Thank you, ma'am. I think the advantage for all of us for today's subject is that because it is as novel and as new, I think all of us are essentially new to the subject, right? So to claim a certain level of expertise, even for people who have done this work for a long time, may be a little difficult because especially with things like metaverse and deepfakes kind of becoming as ubiquitous. I think what has also happened is that everything that we thought we knew about IP has been turned on its head, right? And we are now trying to see what the law can do. Are there solutions even in the law for the problems posed by digital rights management of today's day and age? So these are, I think, some of the concerns that we will try and examine as we go forward, not with the intention of saying that these are the solutions, but to essentially give you some of the emerging trends, the pros and cons of the various solutions that are being proposed, how some of the risks on the internet are being managed, right? And then we'll see, we'll take it from there. Okay. So let's dwell right into it, right? Now, traditionally, the term digital rights management had a very copyright-centric meaning to it. Because it was mostly managing, access to software, access to, audio content, access to video content. When Netflix puts a number of, devices limit, these are the classically understood efforts at managing digital rights. But the recent past, with COVID especially, the scope of digital rights management for most content creators or most brand owners has become much more vast, much more challenging than what it was previously. So we will probably dwell into 2 or 3 case studies involving different kinds of IP rights on the internet, And then let us probably open up the discussion and see how we can tackle some of these emerging challenges and emerging dynamics. Okay, so moving away from the subject of virtual spaces, digital spaces, social media, the internet, software, virtual reality, and so on. Let's go back in time a little bit, right? One of the things that made World War II particularly challenging for the Allied forces is that they were fresh off their experiences from World War One, where battles were won and lost on the basis of a trend called as trench warfare. It was still predominantly land and land driven. Air was not considered to be a theater of conflict as relevant as perhaps land was, to the point where the American Allied troops did not even have a separate air force. So it was essentially the US Navy pilots as well as the US Army Air Corps that essentially fought the war in the air. But what World War II did was that it introduced a new domain of conflict altogether. Suddenly, air superiority became a new determinative factor as to who will win and who will lose. And the fact remained that Germany was ahead of the trend. They already built a very formidable air force, but England was yet to catch up. And this is what perhaps made winning the war as prolonged as it was, because we just did not see the emergence of a new domain of conflict altogether. Therefore, everything from technology to tactics had not evolved to address the new emerging realm of conflict. And I think what the proliferation of the internet and innovations in technology has done for the purposes of IP rights is that it has opened up a new domain altogether. And we are not equipped either in terms of law and policy or in terms of just our ability to physically create the infrastructure necessary to monitor and enforce IP rights on this new domain. And that perhaps is the reason why digital rights management post COVID is going to be more challenging than it ever was. Right? So we first need to understand that everything that the jurisprudence has shaped just in terms of digital rights is first of all recent, and even what it shaped in the recent 30 or 40 years is still unable to catch up with the trends that has emerged in perhaps the last 3 to 5 years. Right? So the need to essentially address this new domain, the need to understand that this is something unprecedented. That is the demands of our times, right? And that's the first thing that we need to be cognizant of. The other thing, of course, is that artificial intelligence has made the entire subject of digital rights management significantly more challenging. So, if today you have celebrities being recreated by artificial intelligence using deep fakes, how difficult is it to recreate, I don't know, a Taylor Swift song by a completely different avatar? And and then who do you go after for enforcing Taylor Swift's copyright? So what this has essentially done is that it has created a new stakeholder in the IP rights ecosystem, which is a non-entity, because artificial intelligence is still not considered a person in most jurisdictions. So who do you sue and who gets to enforce is not a question that has been easily addressed. It is an evolving question, and perhaps may not have many easy answers. Right? Now, the other problem, of course, is that with the advent of the internet and how pervasive it has become in our day to day life, jurisdiction, which is central to our entire understanding of legal rights enforcement, that concept of jurisdiction is as good as completely irrelevant. The reason why we say this is that, let's take an example. In the 90s, us Indians, especially from what I remember, most of the content that I watched from the West was from the 80s, right? Because it actually took that much time for a film that's released in 1989 to come across or travel across the border and come to India, say in the year 1990 or 1991. Most television shows that was running in the West did not even come to the TV shows that we had in Doordarshan, right? But what what the advent of the internet has done is that today, if something releases in the West, whether or not somebody has the rights to broadcast that content in India, chances are that it is still accessible in India. So that then makes the question of jurisdiction that much more challenging and that much more difficult, right? So, and what has not also changed is the fact that our courts and our law enforcement systems are still limited by territorial jurisdiction. Now, if somebody sitting out of the United Kingdom is able to create a deep fake of an Indian celebrity who is based out of Bombay, how do the two enforcement agencies even come together to ensure there is enforcement? So this has essentially made jurisdiction as a concept less relevant. And if jurisdiction is less relevant, everything that we are trained to do as lawyers is, which is so jurisdiction centric, makes the whole process of IP enforcement that much more challenging, right? So this brings us to the next topic, especially in the today's day and age, the challenge of digital rights enforcement or digital rights management perhaps has an equal, if not a greater component of technology awareness as it involves the awareness of legal systems and law and policy. A couple of years back, a friend of mine who's a very well-known technology lawyer was suggesting that the lawyers of the future might have to know how to code. And as interesting as that idea was, I was myself a little dismissive. But as we will see in the course of today's conversation, coding might actually become a skill set necessary for a lot of lawyers in the days to come, especially in the context of DRM. So this is the context and circumstance with which we have to approach the subject that we're going to discuss today, right? And whatever are the limitations that we would proudly wear on a sleeve when we were dealing with clients before, that I'm only licensed to practice in India, I can advise you on Indian law, but not on, say, the laws of the United Kingdom, that I only know law, but not technology. Those excuses will no longer be available to us. Right. And this is the world that you, as legal professionals or people interested in the legal domain, are going to be entering into. So again, going back to what I was saying yesterday, the requirement will now be to know everything all the time. Everything not just related to law, but everything related to the subject, which could be technology, which could be a whole bunch of other learnings that we are not even that we don't even think is relevant today. So bear this context in mind as we go forward, because the traditional understanding of digital rights management has also changed completely in the last 2 or 3 years. So what do we understand by the term digital rights management? A lot of us have probably done work with DRM without even realizing that it's actually DRM that we're undertaking. A simple example of a digital rights management would be when you create an account on Zoom. What features of Zoom becomes available to you when you pay for the service, and what features are not available when you don't pay for it, is in itself an example of Zoom undertaking digital rights management. Okay? Because to understand this in a more fundamental conceptual level, we need to first understand that ultimately what IP is it is the recognition of a monopoly. Right? So if I'm the creator of an application like Zoom, I own the rights to that particular software. I am the monopoly of, I hold the monopoly over it. So I get to regulate who has access to it, how much of access they have to it. This is the essence of monopoly. Right? Now, the monopoly is the strongest when I don't let it out and it remains with me. But we also now realize that a monopoly is without economic value unless it is shared. Right? And how the access to this monopoly is granted, right? Access to the idea at the center of the monopoly is granted. That regulation of access to the idea at the heart of the monopoly is essentially what we call as digital rights management amongst when it comes to the digital world, right? So management of access in general is what IP management is about. But the moment it enters into the digital domain, that is when it becomes it enters into the umbrella term of digital rights management. Right? Now, India found India made its first efforts at regulating or enabling digital rights management through the introduction or through the amendments of the Copyright Act in the year 2012, where, for example, for the first time, the Copyright Act said that if certain technology measures have been introduced by the original author or the owner of the copyright in a work, and those technology measures are sought to be circumvented, that is now prohibited by the Copyright Act. Section 79 is another example where the role of the intermediary, for example, an infringing content is published on YouTube. What is the role of YouTube? What is the responsibility of YouTube to take down that infringing content is what is captured by the essence of Section 79 of the Copyright Act. Thereafter, of course, there was the intermediary rules that came out under the Information Technology Act. These are all efforts at giving some shape and form to in the law for digital rights management. Right? But I think for me, the most interesting development when it comes to digital rights management, which I think has taken the subject out of the exclusive domain of copyright and made it universally relevant to IP, is the definition of a product under the Consumer Protection Act of 2019, where for the first time, the definition of a product also includes a digital product, which has not been defined. So this is where it gets particularly difficult. The term digital product has not been defined, right? So the physical product available in the digital world, like for example, what you buy on Amazon, or does it refer to a software or an application or say a podcast series that you have access to? We don't know that yet. And fact of the matter is, it could be all of this and much more. Now, what that essentially also means is that the subject of digital rights management is no longer centered around protection of musical work, literary work, artistic work on the internet, but it is also now so much more. It could have trademark implications, it could have implications on design. It could have so much more to it than what traditionally has been understood by even the practitioners of digital rights management. Now, this essentially also brings us to the next subject of trying to narrow down the scope of what is digital rights management. So, in its earliest form, you will remember, I don't know how many of you have actually used a compact disk to install a particular software onto your system, right? Before cloud-enabled app deployment became as pervasive as it is today, we would traditionally fall back on going to a store, buying a CD-ROM drive containing Microsoft Office or a Microsoft Windows, bring it back, put it into the system, and then load the entire software. Now, one of the ways in which Microsoft would ensure that only users are using a licensed version was to introduce what is called as a product key. So when you were installing your Office into your system, you would essentially flip the case over, and there you would find a 16-digit, if I remember correctly, a 16-digit product key. Now, if you key that, if you enter that key at the time of installation, the installation goes through and you have a licensed version of Windows or a licensed version of Office. But you don't have the key, then you essentially have an unlicensed version. Now, the moment product keys were introduced, people also found a workaround, which was what is called as a cracked version of the software, where you could install a version of Microsoft Office or Windows without the requirement of a product key. Now, this would be available in the same places that were ironically selling smuggled goods and stolen goods in most cities. Right. One example for those from Hyderabad was Amirpet in Hyderabad used to be a hub of acquiring these kind of unlicensed software which were cracked. Right. In Bangalore, it used to be National Market and Burma Bazaar and all of those places. So product keys obviously was as an effort at digital rights management. Worked for some time, didn't work for probably the most part, and essentially, and this form of DRM has its own limitations, right? Now, the other example of an effort at managing digital rights is the number of licenses that comes to you when you purchase a particular digital product. Netflix is an example. If you buy a Netflix subscription, you might get maybe the right to view it across two devices, maybe across for one or two users. You could buy a subscription that enables you access to two simultaneous devices across four users. So you had different permutations and combinations in terms of the number of licenses that come to you. Same thing with the Kaspersky software. right? The antivirus software. You could buy it for one device, two devices, three devices, two computers plus one tablet. So you have different permutations and combinations. So this is also an example of digital rights management. How many licenses do you get for what you pay for? Monitoring of usage. Netflix does this really well, where they keep a track of which IP address you're trying to access content from. Because bear in mind that Netflix, when it acquires rights to a particular TV show, it is limited by a whole bunch of things, including geography. So the Netflix content available in the US is very different from the Netflix content available in India. Now, if the Indian user uses a VPN to access the US content, Netflix continuously tries to build software to flag it and thereafter, prevent the user from accessing the content. The other example is that they keep an eye on the number of devices from which you're using it because account sharing is prohibited. I can't give my username and password to another user so that he can also access the same Netflix content that I have. So monitoring of usage and keeping a track of data, which also has some serious privacy concerns and surveillance related concerns, is another example of digital rights management. In the recent past, we also saw two very interesting developments in technology, which has kind of made digital rights management that much more interesting. One was the evolution of a concept called as a non-fungible token, NFT. Right? Now, NFT, to put it very crudely, and I could be completely off the mark when I say this, it is, for all intents and purposes, a digital watermark on the digital asset that you have created. It could be artwork, it could be anything under the sun, right? Now, what that NFT does is that it ensures that the original author's identity kind of remains synonymous with the work no matter where it travels in the internet. Right? It's also a investable asset these days. You can essentially buy an NFT token and chances are that it could appreciate in value and you could possibly derive some economic dividends out of it. Now, NFTs are very relevant for DRM, especially for the purposes of today's conversation, because it is one of the emerging trends. Now, the other thing is the subject of smart contracts, which are based on blockchain technology. You will recollect in the introduction and the context setting part of this presentation, we were talking about how lawyers might have to at least understand coding, if not learn to code themselves. And smart contracts are exactly the reason why that statement is now as wise as it is. Because as opposed to traditional contracts, which are predominantly written in natural human languages, smart contracts could involve a blend or sometimes an exclusive software code where conditions and counter conditions are captured in the form of an executable code, and the compliance with one automatically triggers the other. And this has been this has been used extensively, especially in cryptocurrency transactions. Now, smart contracts could also become very, very relevant for digital rights management because what it does is that when content changes hands on the internet, you could now have a system where the terms and conditions of the original license, the first buyer will no longer be in a position to change it as easily as he could change it before when he sells it to a third party. Because smart contracts could essentially ensure that there is a certain repeatability to the terms and conditions of the contract. It improves traceability because blockchain ensures that you have a way of tracking the entire supply chain of the transaction. So all of this essentially now becomes very relevant for the purposes of digital rights management. Particularly so because what you saw in the Consumer Protection Act in the definition of digital product essentially also means that digital rights management will no longer be limited to, say, copyrightable works. It could become so much more now. So let's look at certain emerging trends, right, which could probably be relevant for this conversation. One of the trends that we will have to probably wrap our heads around is virtual reality. Now, virtual reality is best exemplified by Facebook's metaverse product. It is immersive, it's a shared virtual reality. It is a world without borders where you can create digital versions of yourself and undertake a variety of functions, which includes attending virtual concerts, undertaking attendance of virtual conferences, right, where your digital avatars essentially represent you, right? And the use cases are honestly infinite. I mean, we still don't know the full extent of what is possible in something like metaverse, right? And there's already an effort to secure real estate on metaverse, right? Being able to own particular parts of what you create on the metaverse. Now, for something like metaverse, let's take one example, right? So let's assume that I am somebody who is now interested in creating an account on the metaverse. I am a person with some amount of creative talent, though I'm sure a lot of people that I know would beg to disagree with that statement. Now, in a situation where I'm getting onto the metaverse, I now literally have the ability to become anybody that I want. Let us assume that I decide to create a avatar on the metaverse that looks exactly like the famous movie star from Hong Kong, Bruce Lee, who's no more, right? A huge fan of his work, and therefore I decide to look like Bruce Lee on the metaverse. How many of you, and this is a conversation that I want to have, how many of you think, and you can use the show of hands option to begin with, think that Bruce Lee's descendants should have the right to stop me from using his avatar on the metaverse? Priya, you want to answer that? Do you think Bruce Lee's descendants should be permitted to stop me from using a digital version or avatar of metaverse, Bruce Lee on the metaverse? Sorry, Priya, I'm losing you. Not able to hear you.
I think descendants will have the right to sue them, no, sir.
Why? What is the statutory basis that you think will enable you to let's assume the descendants come to you, right, and say that can you help us figure out if we can stop this or not? And if yes, what is the legal or statutory basis for the enforcement action, right? What rights would you invoke?
Is it not that he should take the permission from the residents before doing this?
Okay, so somewhere you feel that the descendants have a right to regulate who
Yes.
can use the likeness of Bruce Lee. Okay,
Yeah.
what is the legal basis for it, right? Do you trace it to trademark law, copyright law, patents, designs? So where do you, because ultimately the question comes back to show me the law that says this is
Enforceability.
capable of being
Enforceable.
enforced. Yes. Okay, let's keep that aside. So show of hands, right? We'll take a quick vote. How many of you think that at least the ethically speaking, right, or morally speaking, the descendants of Bruce Lee must be permitted the right to stop the avatar of Bruce Lee from being appropriated by me? Yes, ma'am. Dr. Pratima, I think you wanted to add in.
No, it's just the show of hand. I think they should.
Yes, there should be. Okay. Okay. And Nagraju, Hasnain, Afzal, what do you guys think? Do you think Bruce Lee's descendants should have the right to stop me from using his avatar on the metaverse?
Yes.
I
Yes.
think yes,
Okay.
Yes, sir. Yes.
Okay.
There is
the
a
burden of
copyright
proof lies on him.
Okay, very good. Excellent. Okay, great. So let's pause here for a second, right? Because this is where things get a little interesting. So in principle, we all agree that Bruce Lee's descendants should be permitted to stop somebody like me from creating a digital version of Bruce Lee on the metaverse, right? How many of you have heard of this movie that came out with Quentin Tarantino as a director? It was a very recently released movie called Once Upon a Time in Hollywood. It had Leonardo DiCaprio in the lead, Margot Robbie also playing a key role, Brad Pitt. It had some really big names performing in that movie. How many of you have come across that movie?
Is it
Okay, I
recently
see.
added?
Very recent, in the probably the last 3 to 5 years. Assuming that's the definition of recent, because I don't know the term, the understanding of chronology has also changed, right? So probably in the recent past, 3 to 5 years. Okay, let's forget that. How many of you have heard of this other movie called set in World War II called Inglorious Bastards? Okay, let's come to an example closer home. Anybody remembers this movie from the 1990s, very popular, called Andaz Apna Apna?
Yes.
Okay. Now, Andaz Apna Apna, is remembered obviously for the comedic content or the humor in it. Now, one of the villain's henchmen in that essentially is an identical lookalike dialogue delivery. Everything is similar to the yesteryear Hindi movie villain Ajit. Right? Do you guys remember that character?
Yeah, no,
Yes.
it's okay.
Okay.
That I have seen.
Yes. Now, the other example that you can think of, this magnum opus from the black and white era, called The Great Dictator. How many of you have come across that movie where Charlie Chaplin essentially made a parody of Hitler? Okay. Now, why am I
That I have
quoting
not
all
seen
of this?
actually.
Okay. Why am I quoting all of this? Because if you notice the way in which freedom of speech and expression works, the freedom of mimicry and the freedom of mockery is also a legitimate right to freedom of speech and expression. Right. Now, Johnny Lever, another famous Bollywood comedian, also is an excellent mimicry artist. He can perhaps recreate the voiceovers and the likeness of most of the celebrities in Bollywood. Javed Jaffrey is another example. Now, you will notice that this is a part of our understanding and proliferation of ideas. Because fact of the matter is a lot of the famous works that we saw were inspired by the famous works of other people, right? And this ability to represent characters from history. And Bruce Lee's character was, and his likeness was used almost unabashedly in Once Upon a Time in Hollywood, right? Where Brad Pitt's character fights with Bruce Lee, the actual Bruce Lee's character, and it's not a lookalike or anything. So it is Bruce Lee's character within the movie, right? So Brad Pitt's character has a fight with Bruce Lee's character and defeats Bruce Lee's character. So it essentially even shows him in a slightly demeaning light in that sense, right? But still protected by the freedom of speech and expression. As difficult as it is for the family of the descendants of Bruce Lee to accept this, the fact remains that freedom of speech and expression permits a certain level of creative liberties to be taken. Right? Now, right, with everything that we know about all the characters in history that we remember for their ability to mimic or represent somebody else who's already more famous, do you still think Bruce Lee's family has a right to stop me from using a digital avatar of Bruce Lee? Or let me throw a slightly different question. Do you think that they would have the right, but subject to terms and conditions?
Sir, subject to terms and conditions, they will have to have their approval.
Okay.
That's okay.
Well, Charlie Chaplin most certainly did not have Hitler's approval for
Yes, sir.
representing, right? And neither did Quentin Tarantino have the right to depict Bruce Lee's character. Freedom of speech and expression essentially means that you can represent this without permission from the family. Okay. So the terms and conditions are then what? Right? If you don't need the permission to use the likeness, what is the terms and conditions that you're gonna advise your client saying, okay, they can use Bruce Lee's likeness to create an avatar on the metaverse, but if they cross a certain line, then you probably have a right to enforce. What do you think that line is?
They
Sir,
are doing
but-
something which are maybe defamatory to the character.
Defamatory, yes, very good. Yes, Priya, you also want to add in?
They can use their freedom, but it shouldn't hurt others' emotions, no, sir.
They shouldn't hurt other emotions. Okay. Now,
They
for some,
shouldn't exploit it in a wrong way. Because
The
Bruce Lee is a
problem-
legend.
now the only in principle, it's a perfectly acceptable statement. But what is likely to hurt somebody else's emotions is an extremely subjective question, right? The mere depiction of Bruce Lee in itself could possibly hurt the family's emotions, right? So, or for example, the other character in Once Upon a Time in Hollywood is this actress Sharon Tate. Sharon Tate was married to the legendary film director Roman Polanski at one point of time, and she was murdered by the followers of a cult movement led by this person called Charles Manson. Now, in this movie, Sharon Tate's character is able to turn the tables on her murderers and essentially prevail and defend herself effectively, right? Now, imagine the plight of Sharon Tate's family members to have to watch a movie in which the entire murder of their family member is trivialized and shown as if she is able to prevail in the attempt on her life, right? But fact of the matter is that freedom of speech and expression, even under Indian law, includes the freedom to offend. Right? The jurisprudence under Article 19 is very clear about it. The right to freedom of speech and expression includes the freedom to offend and provoke. So, would you still say that if they're hurting somebody's emotions, we should stop them from using the likeness? Okay, great. So, the silence in the wake of that question also reveals the fact that we don't really have very clear answers for some of these questions today, right? But if you notice, though we are in the subject of managing publicity rights on a platform like the internet and the metaverse, the principles that we are using to understand the scope of what regulations could be like, we are still falling back on conventional jurisprudence under Article 19 of the Constitution, celebrity and publicity rights as defined under the doctrine of privacy, extended passing off. These are the conventional subjects that we are falling back on to understand the scope of what managing celebrity rights or publicity rights or the right of privacy on the internet is, right? So it tells you that the fundamentals will never stop being relevant. But one of the ways in which we understand what could be a determinative factor to draw that line is whether the likeness is being used purely as an expression of creative liberties and freedom, or is the effort to slavishly make money or economically exploit the legacy of Bruce Lee, right? If there is a modicum of creative liberty, freedom of speech and expression coupled with economic exploitation, the law does not frown down on it, right? But if there is deceit, if there is only the element of economic exploitation and nothing more and nothing less, that is when the law will probably intervene and say, you have a remedy. Somebody like Ashok should not be allowed to just slavishly make money and exploit the legacy of a Bruce Lee. Now, all of these are evolving jurisprudence. It's not set in stone. Right? But fact of the matter is that you now have to worry about how you're going to advise, say, a celebrity client on the management of their personality, their likeness, sometimes the unique elements of their characters on screen, right? And a classic example of this is the recent judgment of the Delhi High Court concerning Anil Kapoor's a certain way of depicting, uttering a dialogue, the dialogue itself, a particular term he employs in some of his movies called jackass, which is now protected as part of his publicity rights. Right? So there are elements of the likeness of a celebrity that can be protected under some very specified terms and conditions. But universal rules of protection don't apply. It's not a case where it's blanket protection. And it can't be that way also for the simple reason that some of the best works that you would have enjoyed watching and reading and generally probably comes out of the imitation of something else that already exists or the likeness of somebody being employed. And the example that I can quote in the world of literature is the works of Frederick Forsyth. Frederick Forsyth is one of the most prolific espionage thriller authors / writers. Several of his novels have been successfully made into movies. And he specializes in a genre called as historical fiction, where actual characters of history are depicted in the fictional plot. And the best example is the Odessa File, where the Charles de Gaulle's character is extensively employed. Members of the actual French resistance are actively referred to. The entire Algerian resistance movement is being referred to with actual characters from history. Same thing in The Fist of God. But today we remember Frederick Forsyth for the fact that he took something from history and then flipped it around and turned it into something so memorable. So to understand how digital rights work in the domain of the internet and in the domain of the virtual reality and so on and so forth, you still fall back on conventional things like fair use. You still fall back on conventional things like Article 19. Right? And the other example that you can think of on the interplay between the world of digital rights management and freedom of speech and expression is the judgment of the court in Tata versus Greenpeace, where the Greenpeace, which is an environmental organization, made a game where you as a character was supposed to protect olive ridley turtles from the economic or the infrastructure development work of Tata group of companies. Right? So Tata decided to sue Greenpeace on the ground that this is disparaging of their trademark, which is also a form of infringement under 29(8) of the Trademarks Act. And ultimately, the court came back and said that the mere use of parody while referring to a trademark would in itself not result in an infringement of trademark and therefore continue to let the game exist. And Tata did not succeed in its efforts to enforce the rights of its brand on the virtual space, which is the computer game. Right? Now, the other examples specific to the metaverse is the recent fashion brands Hermes and Nike in the US, where they were trying to stop the depiction of their brands in the metaverse. And I think Hermes and Nike both ended up succeeding, right? And it also throws up a very interesting problem statement. In another case involving a brand, Juventus, if I remember correctly, one of the questions or the defenses that was taken by the defense in the efforts to protect the trademark was that the trademark Juventus was not registered as a digital product. It was only registered for the physical products, right? Now, digital products could, under the nice classification, come under class 9, right? But if I take clothes, for example, it comes under a different class altogether, 16 maybe, I'm not too sure. Now, if as a brand protection strategy, we are no longer having the luxury of saying that I'll only register the physical product. Chances are that the NFT equivalent of the fashion brand that I own may have to be separately registered under class 9. Though class limitations do not come in the way of enforcement of the trademark, but fact of the matter is that I have to now look at the digital equivalent of my physical product for protection. That is what the metaverses of the world have done to the world of IP protection. You need to now assume that whatever you can touch and feel, like this iPhone, will have a digital equivalent, and you have to look at ways and means of protecting that on the platform like the metaverse, right? And while jurisprudence may still take some time to evolve, what you need to be familiar with is one, principles of extended passing off, the doctrine of privacy for publicity rights especially. And two, you need to invest in technology interventions for monitoring the infringement of your rights on the internet and on the metaverse. You need to, NFTs, for example, could be a way for you to ensure that when you do a screening of the metaverse using an artificial intelligence tool to check if the brand is being reproduced or being misused on the metaverse, the NFT could be the way in which the AI catches the infringement, right? So let me explain this in the context of a more physically relatable example. If you are manning a bomber, right, and you have to drop a particular munition on a bunker, right? How does a plane in the middle of the night know where the friendly troops are and where the enemy troops are? So what the friendly troops do is that they take an infrared strobe, right, and they activate it. And that infrared strobe will be caught by the bomber in the air to know that this is where I shouldn't drop my munitions, right? And that is how it ends up bombing only the enemy and not the friendly troops. NFTs can be the equivalent of the infrared strobe on the metaverse. So when the AI tool is doing a screening of the metaverse to check where your IP is being infringed, the NFT could particularly trigger the AI's eyesight and then help you understand that this is where the infringement is occurring, and this is where your takedown notice should be directed towards. Right? So being able to understand some of these tech solutions to the problem of rights being taken for granted on a place like the metaverse becomes very, very critical. Right? So any questions so far? And these are the buzzwords for you to do your further reading, right? The Hermes and the Nike case laws from California and the United States, the Tata versus Greenpeace judgment of the Delhi High Court, the Anil Kapoor judgment of the Delhi High Court when it comes to publicity rights, right? Doctrine of extended passing off, doctrine of privacy. You fall back onto these keywords, these reading materials to better understand some of the concepts that we're discussing right now. Yeah. And please, if you have any questions, interrupt me, ask me before we move to the next phase. Okay, now we come to the next realm of digital rights management, which is again non-traditional in the world of DRM itself, right? Which is e-commerce. Now, e-commerce could be relevant either for digital products like MP3s being deployed on iTunes, but now it is equally relevant for physical products, right? For example, fashion brands being sold on Tata Lux or an Agio or any one of those online platforms. Right now, one part of this problem statement involving e-commerce and digital content we already dealt with when it came to the Nike and the Hermes example. Right? But what also happens now on the internet is the problem of people using e-commerce platforms to peddle counterfeits, to infringe on physical trademarks and passing off kind of goodwill rights, right? But using the domain of the internet. Now, traditionally, what would happen was that e-commerce players had a certain level of immunity because they were only the space on which buyers and sellers would sell. Right? But nowadays, you also have a concept of an active e-commerce platform provider and a passive e-commerce platform provider. The difference being that in a passive e-commerce platform provider, what the e-commerce service provider does is he provides a platform and then takes a step back and says, this is your digital trading platform. Who owns the space on the platform is the seller. Who gets to make the trade is the seller and the buyer. I have no intervening role to play as the e-commerce platform provider. But in the context of L'Oreal and eBay, especially in the European Union jurisdiction, eBay was nevertheless held liable for the proliferation of counterfeit products on its platform on the ground that it was not just playing a passive role, but it went one step further and offered value-added services to sellers, which included physically enabling them to find the right kind of listing, providing a certain level of metadata-related services where if somebody looked for a rival product, this one popped up as the first item on the search result. So when you undertake more than just a passive role, your role is no longer that of an intermediary. You are an active contributory to the infringement that is occurring on the platform. In those circumstances, the e-commerce platform has been held liable in the recent past. Now, this has a lot of implications even for, say, platforms like Spotify, right? Or platforms like Amazon Music. Because what this does is that it makes them equally responsible to look for imitations, to look for plagiarized content on their platforms, and then provide a mechanism for the actual owner of the copyright to make a complaint and enable them to then have the relevant content taken down. All of this still operates on the assumption, especially in India, that ultimately the owner of the copyright has to go to court and get an order. But what this does is it provides some kind of an interim measure for the copyright owner to enforce their rights on the platform, as it does to the owner of the brand if it finds that there is actually a counterfeit. Right? Now, it brings us to a very interesting challenge, right? And this is one thing that we will have to examine, especially if the seller of the creator of the plagiarizing content, right, exists in Bangalore, but the owner of the original author of the copyright happens to be a singer based out of Los Angeles. Where do you actually institute the action for preventing this proliferation of content? Anybody want to take an answer to that question? The owner of the copyright is in Los Angeles. The infringing content is uploaded by somebody in Bangalore, right? Where do you actually take the infringer to court? Or for that matter, even the platform provider to court? Will the LA courts have jurisdiction? Will the Bangalore courts have jurisdiction? Or will neither court have jurisdiction?
We have the international court.
Sorry?
International court.
Which international court?
There are any international courts. That's the International Court of Justice. It is also there prepaid nowadays.
See, the International Court of Justice is only concerned with what is called as public international law, which is the dispute amongst nations or disputes between nationals and nations involving public international law. Like, for example, the right against genocide, the right against ethnic cleansing. So these are duties under public international law, and therefore there is a remedy available under, say, a forum like the International Court of Justice. But if it is a case involving a realm of private international law, like, for example, domestic legislations that came out of the trade-related aspects of intellectual property treaty, then the International Court of Justice will not have jurisdiction, right? And also bear in mind that under international law, before you approach an international forum, there is a requirement or a doctrine known as exhaustion of local remedies, which means before you jump to an international platform, you have to first take your chances before the local remedies. If those local remedies are either non-existent, non-effective, or don't yield the outcome that they're supposed to yield, only then you are allowed to escalate matters to an international platform. So this is particularly true when it comes to the law of diplomatic protection. So the role of international platforms as it is very limited. Yeah, sorry, I was getting one more answer. Sorry,
I think it is a cross-border issue, no, sir.
cross-border
What you are
issue.
saying.
So where do you go?
I think the one solution I can say is ADR, alternate dispute resolution. I
But
mean,
ADR requires the parties to have an arbitration agreement. If there's no arbitration agreement between the infringer and the owner, how will you invoke an arbitration clause? It's a great idea, though, right? That's a really smart solution to propose. But in the absence of the arbitration agreement, what do you do?
If there is any authority,
Sorry?
if there is any authority, or like, then there we can approach.
Which authority will have jurisdiction over both people in Los Angeles and in Bangalore?
ICJ, sir?
Then I think,
ICJ
sir, it will be Bangalore, because there the offense has been committed, and there the offender is also residing.
Like enacts how the check bounces with the
Spoken like a perfect practicing lawyer. That's a good answer. That's one of the courts that will have jurisdiction is Bangalore, right? And you obviously invoke the doctrine of reciprocal protection under the Berne Convention, where if Indian copyright has protection in the US, then US copyright must have protection under Indian copyright law, right? So that's one way to go about it. But again, to reiterate, the International Court of Justice in a dispute involving a private right of the nature of IP, ICJ will not have jurisdiction. Okay. So one option is the court in Bangalore, of course. The other option is under copyright law, the suit can also be instituted where the plaintiff resides. So technically, even the courts in Los Angeles can entertain a complaint of copyright infringement. They can give an order, and then the person can take that order out of the LA court,
Sir,
come to India, and then try and enforce it or execute it in the Indian court, right? Even that is a permissible route.
sir, but for that purpose, do we need to have for the first thing, for institution of a case in Bangalore, do we do that person, that country has to be signatory to Berne Convention or not?
So more often than not,
If they are
in the
not, then-
context, good question. More often than not, in the context of say copyright, you will notice that most countries are signatories to the Berne Convention, anyways, right? So in a situation where it's America and India, rest assured that they are signatories to the Berne Convention, and as long as they have implemented the Berne Convention requirement of reciprocal protection, then yes, it's more than permissible for them to undertake this kind of a cross-border action. But if they're not signatories to the Berne Convention, or if they're signatories to the Berne Convention but haven't implemented reciprocal protection in their domestic law, then the concept of cross-border enforcement may become that much more difficult. And does that answer your question?
Yes, sir, yes.
Okay. So again, going back to what we were discussing,
One small thing, sir. This Berne Convention will be applicable in the courts. This Bangalore court will understand that. How do we
so the
prove that
Indian
India
copyright
signatory or not?
the Indian copyright law itself has adopted the Berne Convention. So it's not difficult to establish that we are signatory to the
Okay.
Berne Convention. And bear in mind that any international treaty which is done through the channels of any international organization, be it the World Trade Organization, be it the United Nations, if you go to the relevant website of the international institution where the treaty is signed, you can get the entire content of the treaty, including the list of signatories. So this data is freely available on the internet. It really doesn't take much to just find it and then bring it and produce it, right? So it's not very difficult. Okay. So now, why is this example relevant? Because Nagaraju's point is dot on the subject, right? Because one of the critical components of digital rights management in the 21st century is to ensure that there is a proper ADR mechanism built into the efforts at DRM. Right? So your original license agreement on the digital platform must stipulate a mandatory arbitration clause. The consent to that arbitration agreement must be secured and documented in a manner that is accepted by the local court. So you can't have a situation tomorrow where the contract has been executed in a manner that the local courts don't recognize, and then you come back and say there is ADR. Chances are it may not work. So the platform provider must have an alternative dispute resolution mechanism built into the entire terms of use. The original copyright owner must probably try and examine the arbitration agreement as something that I want to incorporate into the license agreement. Because in a cross-border situation, ADR definitely is a lot easier and sometimes a lot more effective than local codes, because ADR, bear in mind, can even be a completely virtual process. You don't have to go physically and sit in the place where the ADR is being undertaken. So in a situation of DRM, where your infringer could be in a different location and you're in a different location, but there's a platform on which both of you have essentially come together, having an ADR mechanism built into the terms of use of the platform could make the whole process of rights enforcement on the digital space that much easier. Right? Is that clear? Any questions? Any thoughts? Now, the next question that I come back to. Suppose the platform provider has not taken steps to build an ADR mechanism, right? Has put in no measures to address this problem of infringement. Can Amazon Music or a Spotify, assuming that they don't take this effort to create a platform for enforcing the digital rights, can they be held liable for contributory infringement or negligence? I'm sure all of you must have done tort law by now, right?
Yes.
Yes.
Contributing
So,
there, sir.
yes. So, is the platform guilty of negligence / contributory infringement, which is a byproduct of the doctrine of negligence, by not creating a mechanism for enforcement of digital rights, for not creating a mechanism for addressing complaints of digital rights violations? Anybody want to take an answer? So the answer I'm looking for is either yes, they're negligent, no, they're not negligent, with reasons. I want to understand why you think they're negligent or not negligent. Afzal, you want to take a shot at the answer?
Sir, actually, contributing negligence will be there because, see, when there is no such laws are there, even though the right will be protected, sir.
Okay. So now negligence operates on the premise of two things, right? One, there is a duty of care, and then there is a violation of the duty of care. So how do you arrive at a conclusion that the platform provider had a duty of care to build in these mechanisms for ADR for enforcement of digital rights?
Little bit confusion, sir.
Sorry?
Little bit confusion.
Okay, no problem. This is, as I said, this is a new subject. All of us are newcomers. There are really no experts in this phase. But the jury is out. We still don't know whether it would amount to an action of negligence in case the ADR mechanism is not built into the terms of use. But if no system is put in place to check infringement, if nothing is being done by the platform provider to address the problem of infringement on its platform, no mechanism is provided for grievance redressal for the original owner, there is reasons to believe that that would be negligence and that would involve civil and sometimes even criminal consequences. Because bear in mind that under the intermediary rules, which has been issued under the Information Technology Act, the platform provider qualifies as an intermediary, and there are obligations to put in place these mechanisms to monitor the platform for the violation of certain laws or rights, and then put in place a mechanism for addressing grievances, if any, that are brought to its attention and notice. Right? So the duty of care can be traced back to something like the intermediary rules. Right? So always never be limited by the thought that this is subject of IP. So therefore, if I don't know the duty of care in IP law, there is no duty. I don't have an answer. sometimes the wisdom to solve these problems will come from an area of law that is completely unrelated, right? Like, for example, tort law, which you wouldn't have ordinarily associated with a course on IP, right? But again, always remember that when you have a problem of emerging trends in legal enforcement or law enforcement, and the law not having caught up with these emerging trends, you bridge the gap by going back to the fundamentals, right? So if your fundamentals are strong in a place like tort or in a place like criminal or civil law, chances are that when you have a situation of this nature where there are no ready answers under the copyright law or under the specialized law, you can fall back on general principles of law to answer these problems, right? Now, being able to take what we know of in the fundamentals of law and applying it to emerging paradigms or emerging problems is essentially at the heart of digital rights management, right? So the creativity it takes to take something under tort and applying it to IP, that is the call of the profession. Okay? So do not think that, oh, I don't know IP law, maybe I shouldn't answer this question. Chances are that because you know everything else unrelated to IP, you are better equipped to answer this question than most IP practitioners, right? That confidence all of you need to have, that if your fundamentals are strong, you can answer any question posed to you. Okay. So let's then come to another interesting case study, right? And this is the last case study before we kind of come to the conclusions of the subject. Take a look at go to Google. I mean, it's a challenge that we can probably do right away, right? Go to Google and think of a brand you want to visit the website of, right? It can be, for example, I was recently trying to make a booking for myself in Chennai for a hearing next week, and I was looking for a particular hotel, which was GLT by Grand. And the moment I went and typed GLT by Grand, the first link that came was not the website of GLT by Grand. It was actually a booking platform where you can book any hotel. So the first, and I in fact clicked it, right? I genuinely assumed that it was the website of the hotel that I wanted to book. Now, this is what you call as keyword triggering, where I, as a brand owner, can go to a place like Google. I pay Google a certain sum of money to bid for a particular keyword, which could be my competitor's trademark. So when my competitor's trademark is searched on the internet, right, or searched on Google, the user will get two results. He will get the sponsored search results and the organic search results. In the sponsored search results, though the competitor's trademark is the keyword, my website comes up first. Okay. This is what is called as keyword triggering. So if, for example, I consider Afzal a competitor lawyer, right?
So
it
is like a digital marketing, like whenever we
correct.
search.
Correct. Absolutely. Absolutely. Yeah. You use the perfect phrase. This is a form of digital marketing. And to break down the example, if I go to Google, I buy the AdWord of Afzal. So when somebody searches for Afzal's name as an advocate, my name pops up first, right? That's what I have done with the keyword triggering exercise. Now, Google provides this service of digital marketing through a platform called as the AdWord platform. Okay. First question, do you think this should be prohibited? Do you think it is fair for me to have my name pop up first on Google when somebody searches for Afzal's name?
No, sir, it should not be prohibited. It is giving some information related to that business, sir. It is directing us to some point of what we are searching.
Okay, excellent. Okay, that's one answer. Anybody who thinks that it is perfectly okay for me to buy Afzal's name as an AdWord, so every time somebody searches for Afzal's name, my name pops up.
From the technical point of view, it is a game of keywords, sir, because it runs on SEO, search engine operations.
Correct. But see, that's often the challenge with law and technology, right? Because look, technology is concerned with how do you ensure that you achieve a particular utility using a particular invention. Technology is then the ethical components of the use of technology is what the law regulates, right? So the question here is that, yes, it is a game of technology, but should the law moderate or prohibit or restrict the use of technology? Okay. Any answers? Somebody who wants to probably argue that I should be allowed to benefit from the significant goodwill and success of Afzal by bidding for his name as an advert. Okay. Let's take the subject of Google search engine off the table, right? Because obviously it's a new paradigm and it's a new technology and whatnot. How many of you have been to a multi-brand retail store like Shoppers Stop or a Big Bazaar? Okay. Everybody has been to
In
it?
the
Okay.
in the website or in the physical?
Physical form. Keep the website, computers, everything outside. Multi-brand retail store, brick and mortar, physical.
Physical, we have traveled. I mean,
Okay.
Shopper Stop, etc. Even.
Okay, let's take a product that we'd like to buy in Shoppers Stop, right? Perfumes and deodorants.
Yes. Okay.
Okay. Now I go into a Shoppers Stop. I am a brand owner. I have a new perfume brand. Okay, I'll call it ABC. So I go approach the owner of the Shoppers Stop brand of retail stores. I enter into a contract with the Shoppers Stop retail store where I tell them that, see, I am a new product. I want to ensure that my products are reaching the consumers. So I'm going to make a deal with you where when you have those big racks of perfumes on your retail floor space, right? The section of the store which has the perfumes. If you ensure that my perfumes SKU, stock keeping unit, is kept at eye level of the consumer, right? Because the shelf is very tall. There is a bottom shelf and there's a top shelf. If you ensure that my perfume brand is available for eyesight at my level, right, at the eye level, instead of the normal 20% margin on the price, I will give you 30%. Okay. But the catch is that it should not be at the top shelf. It should not be at the bottom shelf. It must be kept at the eye level, right? This is the agreement. Is this agreement lawful and legal for me to undertake?
That means already some of the vendors are there.
Obviously,
And I
because
wanted to make it. Yeah,
it's
some
a
of the vendors are
multi-brand
there.
retail
and
store.
Okay. So I wanted to make it all, but already it is there. Already they are positioned in some place. So he cannot make this particular thing that it should be in the eye level. First, because
Okay.
all the vendors, what they will do for the advertisement purpose, they will come in front of that and they will give this, all the customers, when they will come, they will give that, okay, first you smell it and how it is, behavior. They will, after that, it will automatically come, I think.
Perfect. That
If it
was
is a
one
good.
part of it, right? Which is the experience of the perfume, right? How does it smell and whatnot, right?
Yeah.
But if for me to say this is the sample I want to test, right, the tester, I have to first see the product, right? So the agreement
Correct.
here is to say that make sure that my product is more easily seen compared to my competitors' products on your shelf, right? And in return for that, I'll give you more margin on the product.
Definitely, they will place those things before to eye contact only, no, sir.
Is it legal or illegal? Do you think such a contract between the perfume owner, me, and Shopper Stop
As per their
for
clauses,
this arrangement?
as per their clauses, while they
Correct. See, one is the agreement containing the terms and conditions, but an agreement can also be contrary to law, in which case it's not enforceable. The
Yes.
question is this agreement contrary to a law or is it unconscionable and therefore must not be enforced?
Out of my point of view, it is legal only, sir, because market is
It
based
is
on
legal.
profit.
Profit, and more importantly, the buzzword is competition, right? If I'm a new brand and I'm competing against an Armani, I have to essentially do what I have to compete against them by either lowering my prices or entering into these kind of arrangements. It's a legitimate act of competition, right? Now, let's look at it slightly differently. Okay, let's assume that I'm competing with Armani brand of perfumes. So what I will do is I will call my brand, not ABC, I will call it Arman, ARMAN. Okay. And I enter into the same agreement with the Shopper Stop, saying that not only do you keep it at eye level, but make sure that they're next to each other, Armani and Arman. You think this agreement should be enforced? Agreement is for placing Arman products next to Armani products, right?
At the same level.
At the same level. Do you think something like this is legal, proper, enforceable, not enforceable?
I think it is legally enforceable
Is it
unless it
illegal?
comes
Sir,
under the purview of court.
even though, sir,
Okay.
similar names should not be placed side by side, sir. It's illegal, sir.
Okay. Why? Because consumers might get confused that they're buying Armani product while buying the Armand product. Could that
Yeah.
happen? Confusion possible?
Yes, sir. Confusion will be there because the IP itself is restricting, no, sir, uh, to what similar products should not be sold out.
Trademark infringement. Yeah,
Yes.
trademark infringement, right? So you shouldn't create a deceptively similar trademark to an already existing trademark.
Yes,
That's
sir.
the essence of trademark law, right?
Yes.
Now, we had two options. One option where it is ABCD versus Armani. Eye level placement is the agreement. The other agreement is for Arman being placed next to Armani product at eye level agreement between with the same retail brand owner with the brand owner, which is me, right? Perfume brand owner. Two contracts for almost an identical arrangement. In option one, we have no ethical dilemma, but in option two, suddenly we have a legal dilemma, which is that it's an agreement to proliferate trademark infringement, right? Now, why is option one legally allowed and option two not legally allowed? Because option one is an effort at legitimate competition, right? So if you go to a store like Shoppers Stop and you ask for Armani brand of perfumes, they will take you to the section of the store that has perfumes. You are bound to see Diesel, you are bound to see Axe deodorant, you are bound to see Louis Philippe deodorants all next to each other, right? Because that is what a multi-brand retail store does. It gives you options. It allows you to choose between a multitude of products, right? There, an effort by one brand owner to achieve a strategic placement of a product is considered a legitimate act of competition. And this has been specifically held by the US Federal Trade Commission when they examined these contracts called as slotting contracts, right? There's an entire paper available for on it online, right? Where they will examine the legality of slotting contracts from the point of view of competition law. Because when you promote competition, consumers are benefited because the price is reduced, right? And it also enables an ABCD brand of perfume to try and come to the level of an Armani without, stealing their intellectual property, right? This the law permits. But the moment I use Arman instead of ABCD, where I'm trying to slave off the goodwill that has been generated by Armani, then the law says this is not legitimate competition, this is unfair competition, and therefore we will not permit it. Okay. If this logic is true for shelves in a retail space, why is the same logic not true for the placement of search results in a search engine? Right? Because why do I go to Google instead of directly going to the website? Because I essentially know for a fact that when I type in a search term, I will get not only the immediate search result, but I also get all the other search results. Right? I go to Google only for that purpose. So if this logic is true for retail shelf spaces, why should the same logic not be true for online placement of search results?
Because the scope in Google search is more.
Not necessarily. Because Google is like Shoppers Stop. It is essentially placing all the available brands on the search engine. Depending upon who is able to offer a better deal, it will only place the ad in the ad search, sponsored search results. Natural search results are not being affected by this at all. It's only in the top section where you have a disclaimer that says sponsored search results that Google is doing what Shoppers Stop does by saying, give me money, I will ensure that in the sponsored search results, you are strategically placed.
Yes. But sometimes when sponsors a result gives a more economic benefit, like it will be much more cheaper than in compared to the original websites.
Nevertheless, legitimate act of competition.
Sir, where Google is taking an active part in promoting an infringing trademark or an infringing trade name and sponsoring it and putting it at the top of search results, that is wrong, and Google should be held liable for infringing the trademark as well.
But we are not holding Shoppers Stop liable for placing ABCD brand of perfumes at eye level. That is perfectly accepted as a competition.
Yes, sir, that is perfectly accepted because it is a place because Google is not a not-for-profit company. It's a company that has been established to make profits. So if
Shoppers
they're
Stop also.
yes, sir. So if they're sponsoring, if they're taking money to promote a product, say ABCD versus Armani, that's completely all right. That's completely okay. Because Armani can also come ahead and pay a bit more money to promote and put their shelf products, put the products
Perfect.
at the aisle.
Perfect. So what we are saying is that so long as there is no confusion being caused by the deceptive similarity, then it is perfectly okay to place the ad results in any manner that Google decides to enter into, right?
Yes, sir.
So this is the reason why we take this up is that there is a school of thought that was prevailing, especially in the spate of judgments by the Delhi High Court, where they said that the logic applicable to multi-brand retail stores need not be true for the internet. It's called online exceptionalism, right? To argue that virtual spaces should be regulated not the same way that physical spaces are regulated to determine IP infringement, right? So for the longest of time, in a series of judgments, starting with Bharat Matrimony and Shadi.com, all the way till Make My Trip and Agarwal Packers and Booking.com, that this kind of placement of search results in the absence of infringement of trademark was still held to be infringement of trademark and passing off on the ground that it is taking unfair advantage of a trademark under Section 29(8). In a recent division bench judgment of the Delhi High Court, the court has taken a diametrically opposite view. They've examined all the single bench judgments and they finally come back and said if there is no confusion being caused between the two placement of the search results and there's no infringement or passing off of the trademark, then you can't say that it is an act of passing off and it must be promoted because it is a legitimate act of competition, right, and not confusion. The same view was taken by the Competition Commission also so the same view was also taken by the Competition Commission while examining the complaint of Bharat Matrimony against Google. And they said that, see, so long as the placement of the results are not causing confusion, then it is essentially a permissible or promoted act under the Competition Act, because the Competition Act is there to promote free competition. But the moment you are trying to slave off the trademark and trying to pass off your goods as that of the other, that is when you have a problem so far as IP law is concerned, right? Now, this brings us to the last piece of wisdom for the day, which is that do not assume that simply because it's the digital space, the rules applicable to a physical space will not be applicable, right? Unless there is some compelling reason to show that this has to be regulated differently, rights as regulated in the physical space will probably apply in equal measure to a digital space as well, right? So this brings us to the last leg of the conversation today, which is about enforcement. And these are some trends that it is useful for all of us to know. So one is increasingly there is blockchain-enabled smart contracts being entered into instead of the well-known textual contracts that you and I are familiar with. This is a blend of a contract represented through natural languages like English, as well as through a software code, right, which will determine that if party A does ABCD things, then EFGH things which are supposed to be done in response will be done automatically, right, without there having to be an intervention. Now, this is something that is very common in, say, cryptocurrencies, transactions involving non-fungible tokens. So there is a lot of benefits to this for the simple reason that if I license an NFT, right, a non-fungible token on a digital artwork, and I do it using a smart contract, when my buyer ends up reselling it to a third party, my smart contract can be coded in such a way that the same terms and conditions and encumbrances goes with the artwork, right? Which advantage may not be possible in a pure natural language contract, right? Where if the buyer does not make the effort to recreate the terms as it is, then it's anybody's guess as to what kind of terms and conditions he'll enter into with his buyer, right? So the ability to regulate the digital right across the entire journey it undertakes on the digital space becomes easier with a smart contract. With an NFT token, what it also does is it ensures that your watermark or your identifying factor as the original author remains with the work no matter where it goes on the internet, right? So it enables you to better enforce your moral rights, the right of authorship, the right to not have your work defaced or modified or amended. All of this becomes easier to manage with a combination of NFT and smart contracts. The problems, on the other hand, is that a lot of jurisdictions still don't have binding regulations that tell you whether smart contracts are legally recognized or not. For the present, so far as offer acceptance and consideration is there, there's no reason why it should not be enforced. But the problem is in terms of how do you document consent? How do you document offer and acceptance and consideration? So that is something that the smart contract author will have to apply his mind to and ensure that it is legally compliant. Then the other problem is when it comes to dispute resolution, you have triggers that are built within the smart contract. So the smart contract is essentially a code where you have already given it a certain definition of a dispute. If those parameters are satisfied, an arbitration proceeding is automatically initiated by the smart contract itself. But then how do you define a dispute, right? Because suppose if both parties are agreeable to the existence of the contract, but for purposes of compliance, for purposes of foreign exchange, they want a declaration from the arbitral tribunal that there is actually a valid agreement existing between them. Then there is no dispute in the traditional sense, but there's still an arbitration. In those circumstances, how do you define a dispute within the code of the contract becomes very difficult. That is again something that is yet to be fully addressed in terms of regulations. So there are also problems on how do you know whether there's consent to the agreement or not, because I think none of us have read the terms of use of any application that we have signed up for. In the absence of that kind of knowledge of the terms, in the absence of that kind of informed consent, is that consent even consent for the terms of the agreement is not yet decided. So these are some things that are still yet to be understood, right? But the trends are essentially leaning in favor of smart contracts getting more and more legal recognition. You even have something called as the JAMS arbitration rules being made only for smart contract dispute resolutions, right? You can go to the website, look it up, but it tells you now that an arbitration in the conventional sense, where you would sit before a physical arbitrator, present a claim, present a counterclaim, lead evidence in person, all of that now can be done virtually, right? And enforcement is also now available virtually. The United Kingdom even has something called as the digital dispute resolution rules that are being contemplated, right? All of which could be the go-to the institutions tomorrow to enforce your digital rights. So getting some familiarity on technology interventions for digital rights management is perhaps now more important than knowing the tort law or the IP law, because all the knowledge in the world is useless if you do not know the smartest way of enforcing it, right? So building your familiarity with these technology interventions becomes very critical. And that is also now equally incumbent amongst the lawyers. As relevant as it was for engineers to know the law, now it is equally important for the lawyers to know the technology, right? Indispensable. The American Bar Association, as part of an ethical obligation on lawyers, requires them to be up to speed with technology. It's an ethical obligation of lawyers in today's day and age, right? Indian Bar Association needs to catch up, right? And we all have to really undertake that level of skill development, without which subjects like digital rights enforcement becomes very difficult for us to understand and meaningfully advise clients on, right? So to come to the concluding factors, digital rights management is not just about copyright anymore. It is so much more than that. It's not just about law anymore. It's also as much to do with technology, right? Which then brings us to the next question, that it's important for us to constantly upskill with technology as well. We need to know Web 3.0. We need to know blockchain. We need to know smart contracts. We need to know artificial intelligence, right? We need to know the role of intermediaries, difference between passive providers of e-commerce platforms and active providers. Without that, it becomes very difficult, right? Because jurisdictions have been diluted by the internet, comparative law as a subject for law students is perhaps now more important than it ever was in the history of lawyers, right? Because the moment disputes span across borders and across legal systems, common law, civil court, Sharia, it is important for us to be able to talk intelligently across these legal systems to be able to do justice to our work, right? And cross-border networking is the absolute need of the hour. If you have a situation of a copyright owner in Bangalore and infringement occurring in LA, if you don't have the networks with good lawyers, law firms, and law enforcement professionals in these jurisdictions across borders, you can't do justice to your work. So get into an organization like International Trademark Association, step into these kind of events, conferences, network with professionals from other jurisdictions, because without that, something like digital rights enforcement can't be done meaningfully, right? So these are the key takeaways that I would want to leave with you, right? Any questions or thoughts? The floor is now open, provided we have time.
I'm sorry, I think we are running out of time, so we might not be able to take questions now, Ashok. But certainly, if should the participants have any questions, please write to Ashok on the email that is provided here, or you can also reach out to him. We are really running short of time because we have another session to go. So I don't think we'll be able to take up much on the questions, but very, very relevant in the present age and time that we need to understand the subject of digital rights management, and more importantly, of what Ashok has left us with the thoughts of what we need to do. Right, because we are encountering a lot of these cross-border issues here, and understanding technology. And we are not just lawyers anymore. We have to understand technology, otherwise we'll be left far behind. That's a very, very important takeaway for all of us through this session. And thank you very much, Ashok. We will touch base with you for more questions and clarifications as the students would want to reach out to you. Thank you so much.
Thank you.
Thank you, sir.
Thank you.
Thank you
Thank you.
for your valuable insights. Thank you.
Yeah, we will do one thing. We'll have a quick short break, and we will resume the session at 3:30. Is that okay?
It's okay.
Scheduled time was 3:30. We will just resume. We'll just take a 15-minute quick break, and we will resume at 3:30
Sure.
for a subject on IP valuation. Thank you all.
Thank
Thank
you.
you, Ashok.
Thank you.
Thank you very much.
Thank you.
Thank you.
Thank you.